Dubin, I understand that we could stop at the end of QP1, say it's not jurisdictional, and remand and have fun with the sua sponte question. But the QP2 is, if the government were to have actually objected or might in a future case, seems to me pretty important and likely to impact a very, very large number of immigration appeals. And therefore, I wonder whether the government's view, whether it does make sense for us to go ahead and address that now so that everybody has clarity on the playing field.
Yeah, so the courts of appeals all agree that an issue of exhaustion is required under the INA, that this provision, whether you read it as a statutory or regulatory obligation, agency rules require issue exhaustion.
Having to refile a petition, for reconsideration, that question is what I'm aiming at.
So I did want to highlight that the most important thing is that the normal context in which this comes up is from an immigration judge to the board, right? You didn't make a particular claim against what the immigration judge when you appealed to the board.
Put that aside. I'm talking about from the BIA to the Court of Appeals. Can the Court of Appeals take it up when there could have been, theoretically, a petition for rehearing to correct the BIA's faulty reasoning, okay? I would think that comes up an awful lot, or could come up an awful lot, especially if we don't answer the question. And so I'm just wondering whether the government would agree that it makes sense for us to go ahead and address that question.
I think it nearly always comes up in this context when you have an impermissible fact-finding claim,
right.
Because that's the type of claim that the board is introducing a new error, and that's when it comes up that you would have a jurisdictional exhaustion requirement say that you needed to raise that to the board. And I do think it would be helpful to address that if the court was going to give clarity to that area.
Thank you.